When a federal supervisor discriminates against an employee on the basis of race, sex, religion, national origin, age, or disability, the law does something very specific. It does not make the supervisor pay. It does not make them write a personal check. It does not put their house savings or future at risk. Instead, the law funnels the entire financial consequence onto the agency, which means onto the American taxpayer. The supervisor who committed the violation is defended by lawyers paid for by the public and keeps their job, their salary, and their power. This is not an accident. This is how the system was written. Title VII of the Civil Rights Act of 1964 prohibits discrimination in employment, but for federal employees, the rule is even more explicit. When a federal employee files a civil action, the law states that the head of the department shall be the defendant, not the supervisor who made the decision, not the manager who engineered the retaliation. Federal courts have repeatedly held that individual supervisors cannot be held personally liable. The result is a clean shield. The individual is insulated from personal financial judgment. Before a federal employee can even reach a courtroom, they must survive one of the most protracted administrative systems in American employment law. It begins with counseling, then a formal complaint, then an investigation that can take 180 days or longer. It is a system designed for endurance. Then comes a choice, an administrative hearing before a judge or a final agency decision. Either way, the clock continues to run for years. Throughout this process, the supervisor is represented by Department of Justice attorneys at no personal cost. The employee usually pays their own lawyer or goes unrepresented. While the clock runs, careers stall and health deteriorates. Many simply quit or settle because they cannot afford to continue the fight. Retaliation is the most frequent basis of discrimination. The system supposed to protect employees often becomes the vehicle for further pressure. When a finding is finally made or a settlement reached, the money almost never comes from the supervisor's pocket. The shield remains intact. When a federal EEO case results in a settlement or judgment, the money almost never comes from the individual supervisor. It comes from the Treasury. Payments are often drawn from the Treasury Judgment Fund, a permanent, indefinite appropriation that exists to pay judgments against the government. Under the No Fear Act of 2002, agencies are required to reimburse the fund. That money comes from the agency's budget. It is taxpayer money twice over. In fiscal year 2023 alone, more than $202 million in monetary relief was reported for federal workers and applicants. This does not include attorney time or investigation costs. While the public pays the bill, the supervisor continues to draw a federal salary, continues to accrue retirement credit, and almost always remains in authority. Disciplinary action is possible, but it is neither automatic nor common. Due process protections for supervisors make removal difficult even after a finding of discrimination. The architecture is clear. The financial pain is socialized across the tax base. The personal risk to the decision maker is minimized. The system protects its own. This is not merely a gap in the law. It is an incentive structure. This design serves a very specific purpose. When a supervisor knows that the worst financial outcome is that the agency will write a check, the deterrent effect of Title VII is dramatically weakened. The employee knows they face years of process and the near certainty that the individual who harmed them will not suffer. Many simply choose silence. Taxpayers fund both sides of the conflict. They fund the defense of the agency and they fund the eventual settlement or judgment. The only party who routinely bears ongoing personal financial risk is the employee who was wronged and the counsel who represents them. This logic extends into many state systems and into the private sector. Where individual liability is weak, power has less reason to fear the consequences. When the person with power has no reason to fear the civil rights consequences of misusing that power, the system itself becomes the accomplice. If the goal is a cleaner government, federal, state, and private, then the financial consequence must follow the decision maker, requiring managers who engage in intentional discrimination to bear a substantial personal share of the monetary liability would reverse the current incentive. It would not eliminate agency liability. The employer still controls the workplace and remains responsible. It would simply end the current free ride. A supervisor who knows that a finding could cost them their own assets or retirement will think twice before using race, sex, or age as a weapon. Agencies would still have incentive to train and remove bad actors because they would retain residual liability, but the individual would no longer be insulated. This is not radical. Other statutes already impose personal liability on managers, the Fair Labor Standards Act, and certain state anti-discrimination laws among them. Title VII simply chose a different path. That choice has a cost paid every year by the employees who endure the process and by the taxpayers who fund the settlements. A government that claims to lead on civil rights cannot simultaneously maintain a system where its own managers violate those rights with near total immunity. If we want cleaner organizations, the burden of proven violations must return to the people who chose to commit them. That is not vengeance, that is accountability.